Hello, and welcome back to Constitutional Fraud. I'm your host, William Toppi. In this episode, we'll take a look at my chaotic journey through the world of prison classification. It's supposed to be impartial, guided by clear rules and standards. But as we'll discover, in my case, it was yet another chapter in a story full of deception and manipulation. We'll delve into the consequences of receiving a fundamentally disparate sentence. This unique sentence, which I personally experienced, stemmed from the plea bargaining process in a Massachusetts Superior Court, presided over by Judge David Ricciardone. It's essential to understand how such sentences can dramatically affect individuals. This episode will examine the profound impact of my specific sentence and highlight how it extended beyond the conviction. We've previously discussed the shocking deceit and unethical behavior that marred my case. Now, I'll reveal how the same deceit and misconduct followed me into the Department of Corrections, subjecting me to years of torment and threats. But remember, I'm not alone in this ordeal. What I've faced is not an isolated incident, but a harrowing glimpse into a deeply flawed system. In our previous installment, we examined the sentence pronounced by Judge David Ricciardone. He imposed a committed sentence of 2 to 2.5 years of incarceration on count 2, larceny. This sentence was intended as retribution for the theft of an extensive array of property. Moreover, it carried financial penalties, including a $90 victim witness fee and a $150 indigent counsel fee. However, a crucial aspect was glaringly absent from this punitive decree: a definitive identification of the stolen items or their monetary value. Moreover, it conspicuously omitted any provisions for restitution for the larceny, which is an essential component of probation. Effectively, this sentence had to be borne without clarity on what was precisely stolen or its value. The issue of restitution was explicitly addressed in the context of the sentence I received for count 1, breaking and entering. This sentence consisted of 2 years probation, which was scheduled to begin after the completion of the committed sentence. The conditions of probation included restitution, which was set to be determined at a later date. Now, the pivotal part here is the mention of that, referring to restitution. You see, it was ordered that I pay restitution on that. And that can only be associated with the breaking and entering, as I had already served the full punishment for larceny. This unique and disparate sentence created an ongoing problem for years to come. The blatant disparity within the structure of this particular sentence brings to light significant issues regarding the administration of justice in Massachusetts. The lack of clarity regarding the application of this distinct form of justice, combined with my personal ignorance about what I was truly being penalized for, underscores the pressing concerns within the state system. And now a word from our sponsor. This episode of Constitutional Fraud is brought to you by the Eighth Amendment, with its vague description of prohibiting the infliction of cruel and unusual punishments, often mentioned in the context of the death penalty. It also mentions excessive fines and bail. Now back to our episode. Upon my arrival at the infamous Walpole State Prison, I went through the standard processing procedure, was provided a bedroll and green clothes assigned to new inmates. I then began my journey down the facility's expansive corridor. This experience felt like a journey back in time to a different era. Walpole, originally constructed in 1956, has a long and troubled history characterized by violence and inhumane conditions. It was officially closed down in June of this year, 2023. Upon reaching my assigned block, carrying my bedroll, felt as like I just walked into a movie set, with all eyes watching the new arrivals as we entered the block. I was utterly drained by the harrowing experiences of the preceding 3 weeks. That night, I laid in my bed with the voices of inmates echoing back and forth. Walpole, being an antiquated facility, featured open bars in the cell's door and front wall, reminiscent of what you might see in classic movies like Escape from Alcatraz, starring Clint Eastwood. 1 week after the fraudulent conviction, Christmas arrived unceremoniously and swiftly departed. My thoughts were consumed by my 11-year-old son, my 16-year-old daughter. The previous year, I had sung in the Christmas choir at the Concord State Prison. I distinctly remembered the sense of hope and the warm embrace of God's love I felt. However, this year was strikingly different. I roamed the desolate yard of Walpole alone. The sky was overcast and gray as I walked, listening to the crunch of the gravel beneath my feet. My hands were buried deep in my prison jacket, fend off the biting cold. I felt like a broken man, emaciated, feeble, and utterly abandoned by all. I questioned the twists and turns that had led my case to such an unthinkable outcome. At the age of 48, I questioned how I could ever hope to pick up the shattered pieces of my life. After discovering my assigned seating in the chow hall at the Suffolk County table, being from Lynn, I reserved to consume as much food as I could, all the while engaging in push-ups and pull-ups. In Walpole, a stock and hash reality hangs in the air. At any given moment, you might have to fight for your very existence. My physical condition was far from optimal. I was in a profoundly weakened state. As my first week in Walpole passed, I decided to complete a canteen slip. I was aware of some money coming with me from Plymouth, and I needed the essentials like soap, toothpaste, basic hygiene items. Additionally, I yearned for coffee and protein to help stay alert and regain some of the muscle mass I lost. To my disappointment, however, my canteen funds were confiscated to offset the $90 victim witness fee. Typically, these fees are settled after the committed sentence while on probation, and it's quite unusual that all of an inmate's canteen funds are seized to pay such fees, thus placing the burden of payment on my family. My unique sentence led to these fees being assessed along Count 2, larceny, my committed sentence. I remained unaware of this for weeks as I awaited the canteen. The docket indicates that on January 2nd, 2015, the $90 fee was paid. Following this revelation, I contacted my mother-in-law, who sent an additional $200. This would enable me to cover the remaining $150 fee and still have enough funds left for the essentials that I so desperately needed. Nonetheless, it would be more than a month before I received any canteen items. I was fortunate enough, however, to find camaraderie in the most unexpected of places. A fellow inmate from my hometown of Lynn, who shared his coffee with me from time to time. And to bolster my calorie intake, I often resorted to consuming large amounts of bread and butter that I scrounged from the chow hall. In a place like Walpole, where survival can be uncertain, these small acts of kindness and resourcefulness went a long way. After a month, I found myself relocated to a different block where my drab gray prison attire replaced the green. It was in this block that I would undergo the classification process to determine which correctional facility I'd be sent to. As I talked with fellow inmates about our sentences and shared my own, I was met with constant disbelief. Everyone echoed the same sentiment. They had never encountered a sentence like mine before. These conversations ignited my curiosity about what had truly transpired at the Lowell Superior Court under the gavel of Judge David Ricciardone. Then, the day came for my classification, a process within the Department of Corrections guided by specific criteria akin to the court's guidelines for plea bargains. Allow me to share my classification report with you. It's 2 pages. The first page has the criteria that they give you a score on. The severity of current offense, mine was low, so I got a 1. Severity of convictions within the last 4 years, 0. I had none. History of escape or attempts of escape, none. I didn't have any. History of prior institutional violence within the last 7 years, none. Age, 47, minus 2 points. Education, minus 1. The total score came to minus 2 points. And on the second page, it says my preliminary custody level recommended was minimum security or below. However, there was it says code B, outstanding legal, and that didn't happen. According to this system, a score of 6 points or less, I don't need my glasses for that, makes an inmate eligible for placement in a minimum security facility or even pre-release. However, the presence of falsified documents inaccurately indicating the location of the crime as Wilbraham in Hampden County instead of Wilmington in Middlesex County signaled that the shadow of fraud had followed me from the courtroom into the prison. Much like my previous experiences, I remained blissfully unaware of these developments. Behind-the-scenes maneuvers seemed to be at play, orchestrating additional pain and suffering while meticulously hindering any prospects of successful re-entry into society. It was as if I was intentionally being set up for failure. Instead of minimum security for a nonviolent offender who was 47 years old and with minus 2 points, with a year left to serve, I would remain behind the wall. I was transferred back to the Concord State Prison in late March of 2015. Immediately, I reached out to Attorney Deborah DeWitt, seeking her assistance in rectifying the false minimus. The aim was to facilitate my reclassification into a minimum security facility, as I believed this was the right course of action if I was ever going to reestablish any kind of prosperity, what remained of my shattered life. Let me share the letter I received in response from Deborah DeWitt. There is no breach of attorney-client privileges here, since she never actually represented me as an attorney to begin with. Read my glasses and find that letter. So I reached out to her and I received this letter on March 16th. And it says, Dear William, I did receive your letter. I need to know what I can do for you. Do you need the statement of the case, your record, a letter from me? I will do whatever I can to help you move along in the system. Signed, Deborah DeWitt. To my dismay, there was no help forthcoming. More astonishingly, I remained oblivious to a significant development. Deborah DeWitt had filed a revise and revoke motion just a day after the conviction, a motion that could have swiftly rectified the flaws in my disparate sentence. I'll read this motion to you as well. The very day after my sentence, this revise and revoke with an affidavit was filed. And it states, now comes the defendant in the above captioned matter and moves this honorable court pursuant to Massachusetts Rules of Criminal Procedure 29 to revise and revoke the sentence imposed on him by Judge Ricciardone sitting in Lowell Superior Court on December 17th, 2014. Then it says, the defendant is nor requesting a hearing on this motion at this time. See attached affidavit. On the affidavit, it says, I represent the defendant in the above matter, He received 2 years to 2.5 committed sentence to state prison with 2 years probation on and after with conditions. The defendant is filing this motion to preserve his rights. The defendant is not requesting a hearing at this time. The date is, actually it's the same day, December 17th, the day of my sentencing. As you can see, curiously, the motion stated that I was not seeking any revisions to the disparate sentence. You can also see that the filing of this motion was not addressed in her letter I received asking for her assistance. It gets even more bewildering. The docket reveals something puzzling. A hearing for a change of plea had been scheduled for December 23rd, 2014, a mere week after my sentencing. Intriguingly, this date also marked the 1-year anniversary of my arraignment by Judge David Ricciardone, during which he specially appointed attorney Deborah DeWitt to represent me, even though she wasn't on the list of appointed counsel. The docket further states that this hearing was rescheduled, but to my surprise, it never was. I remained in the dark about the details regarding who scheduled, canceled, or rescheduled this hearing, and more importantly, why it never took place. At that time, I was preoccupied with the daily struggle to survive in the harsh conditions of Walpole State Prison. I was moved to the West Up block at Concord in April of 2015. This was where I was designated to serve out the remainder of my time. Many of the inmates housed here were doing serious time, including men serving life sentences for murder. It was a harsh and brutal environment. Recognizing the looming issue concerning my -2 points in the classification system, I decided to take action. I approached the classification officer and requested an appointment to address and hopefully resolve the conundrum that was preventing my progression. Regrettably, the response I received was a convoluted runaround with no concrete answers to my pressing inquiries. It appeared that the path to clarity was intentionally obscured. Subsequently, I had the fortune of encountering an inmate who advised me to write directly to the court, so I followed his advice. Unfortunately, my letter to the Lowell Superior Court went unanswered. Realizing I needed to escalate the matter, I decided to contact the Woburn Superior Court. My letter to them was received and officially filed with the court on April 27, 2015. Armed with this confirmation, I filed for an early classification request on May 22, 2015. The request was granted and approved on June 28, 2015. The green light was given for my transfer to a minimum security facility where I hoped for a fresh start. However, my attempts at seeking clarity seemed to have garnered the wrath of some individuals involved. The clerk of courts in Lowell, Michael Mahoney, apparently took offense to my pursuit of answers. In response to my letter to the Woburn Superior Court, he initiated a series of letters falsely asserting that I owed a $150 fee. Strangely, I was unaware of this situation until my release, when I attempted to renew my license and discovered this supposed outstanding fee. As it turns out, the $150 fee had actually been paid on February 2, 2015, through funds seized from my Canteen account, much like the earlier $90 fee had been. It was yet another falsified docket entry to cause harm and further hinder me. During this time, I secured a job tending to the walks and grounds of the prison. My days were spent walking around the prison premises caring for the plants and flowers. It was a sweltering hot summer and the heat was relentless. Inside my block, West Up, we encountered additional challenges as the water heater malfunctioned, leaving us without any hot water. The walls in the block and the cells seemed to sweat with moisture, while the showers were as icy as water cascading off of a glacier. Frustration and anger simmered among the men, and fights erupted over the hot water tank in the break room that was provided for heating coffee or food. Men began to seize it and use it in the shower for a bath. Because of my role as a worker, I managed to secure a transfer to the mods, aided by the assistance of some fellow inmates with whom I worked. By late June, I had successfully moved to the mods, with substantial improvement over West Up. The mods had a welcome advantage of being air-conditioned, and the showers were cleaner, individual units, as opposed to the communal, frigid showers of West Up. My new living situation involved sharing an air-conditioned 8-man room with several of those men also serving life sentences for murder. In contrast to the perpetual tension and looming threat of violence that defined life in West Up, the mods offered a significant reduction in such stress. The daily tension that had once been a way of life in the prison considerably dissipated for me in the mods. My parole hearing occurred on June 22nd, 2015. This is the same parole board who will be reviewing my petition to the governor at the conclusion of this series seeking a pardon. During this hearing, the parole board had access to all of my relevant information: the glaring disparate sentence that failed to align with the Massachusetts sentencing guidelines, the erroneous minimus that falsely identified Wilbraham of Hampden County, and my impending reclassification to a minimum security facility after the substantial amount of time and inquiries I made to rectify the situation. At this hearing, one of the parole board members asked me to identify an object I had stolen from the home during the crime. But I responded truthfully, just like the facts that were read in the court, maintaining that I had not stolen anything and I was entirely innocent. Let me read you the parole denial that I got. It was to go to the West Up, but I was moved to the mod, so we went there. So the date is 7/22/2015. Please be advised that the parole board voted to deny you release under parole supervision. Final disposition denied. Reason deny. Concerning criminal behavior, subject exhibits limited insight and responsibility for his criminal behavior. Release does not meet the legal standard. Three months after being approved for the transfer to the minimum security facility, I was moved across the street from the Concord State Prison to the Concord Farm. A move like this could have taken place much sooner. In late September, I arrived at the farm. I didn't have enough time left to qualify for pre-release and work to have any money saved upon my release. To put it in perspective, some of the men I got to know at the pre-release section of the farm had tens of thousands of dollars saved for their release back into society. To add an extra layer of complexity to this story, my estranged wife happened to work right next door to the Concord Farm. There was an active restraining order that legally prohibited me from being anywhere near her workplace. The Department of Correction was well aware of this, and I specifically requested not to be placed at the farm when I was reclassified. So in my final days of incarceration, I spent my time roaming around the fields outside and unsupervised, right next door to my wife's job, with an active restraining order prohibiting me from being anywhere near there. This continued until my release in December of 2015, just before Christmas. A broken man who was homeless, without any funds to support himself and absolutely no rehabilitation for a successful re-entry into our society. In the next episode, we'll explore my life on probation, the initial challenges upon returning to society, and the threat of probation violations that it could have catapulted me back into a decade of incarceration. I'm your host, William Toppi, reminding you that our pursuit of justice begins with you.